And welcome back. We are commencing the first segment of our show this morning. We have with us on set Senior Counsel Eamon Courtenay. As we mentioned prior to the commercial break, our first discussion for this segment will be the outcome of what we call the Petrocaribe Fund case. Good morning, Senior Counsel.
Good morning, Isani. Morning, Marlene.
We know that the decision was somewhat delayed based on the initial schedule that was given by the Chief Justice. Nonetheless, the ruling has been seen by some as a split decision. Let's start there, because I know that the $1.5 billion in public expenditures has been deemed unconstitutional. But at the same time, the injunction that was also being sought, what do we say? The effect of it has been postponed until after a 6-month period. And so I think that's what kind of gives the impression to some that the ruling was sort of 50-50. Let's begin with your impression on that.
Well, I think that spin is put out there by the Financial Secretary, obviously after speaking to his political bosses. It is hogwash, complete nonsense. Let's remember what this is all about. We asked for 4 reliefs from the Chief Justice, and we got 3. That is not split. That is a victory. I want to make the point that the first thing that was sought was a declaration that the expenditure in 2012, 2013 was unconstitutional. That is the so-called $100 million slippage. Chief Justice says that that was unconstitutional. The second thing that we sought was a declaration that the Section 5 of the Petrocaribe Loans Act that provides for expenditure for urgent and unforeseen expenditures can be made out of the Consolidated Revenue Fund rather than the Contingencies Fund was unconstitutional, and he disagreed with us. The third thing was the $1.5 billion, so it's the $100 million plus the additional 21 bills that were brought to the House, supplementary bills that were brought to the House. He declared that to be unconstitutional. So that is 2 out of 3. The fourth one was the injunction. The Chief Justice granted the injunction. So he did give a judgment in our favor. What he said is that he's going to suspend the effect of it for 6 months to give the government an opportunity to correct, by constitutional amendment, all these wrongs that it has done.
Retroactively as well.
Retroactively. So it is a victory for Belize. It is a victory for the party leader and the Honorable Justice Spat. It is a victory for transparency. It is a victory for accountability. It is not a split decision, and let us not be deluded or fooled by the spin of the United Democratic Party and their operatives. This is a serious indictment against the way in which they have been managing people's money, public funds, contrary to the Constitution, criminally contrary to the Finance and Audit Reform Act.
And that's kind of where I wanted to start to put the conversation into context. You know, for people just tuning in, they know it's a major ruling, but it's understanding why this case was brought before the court. In fact, the Finance and Audit Reform Act was passed in 2011 under this administration, who was taken to court. Talk to me about what that specifically outlined and where the breakdown took place in terms of not following through with what the Act dictates.
Just to be clear, Marlene, the Finance and Audit Reform Act was passed in 2005 by the People's United Party under the leadership of Said Musa.
And amended.
It was amended in 2010 by the government of the United Democratic Party. The most important amendment in 2010 by them was to make it a criminal offense to violate any of the provisions of the Finance and Audit Reform Act. So, let us remember what is happening here. Under the Constitution, there's something called the Consolidated Revenue Fund. All monies borrowed or raised by Belize, meaning by taxes, go into that fund. A budget is prepared on an annual basis, and you say, I'm going to spend $100 million on national security, $300 million on education, etc. It goes to the National Assembly, and the National Assembly approves that budget, which means that each ministry is now authorized. The Minister of Finance issues a warrant and says, 100 million was approved for your ministry, 200 for yours. Here is a warrant. You can take that money out of the fund. As the money is coming in, you take it out. So it is authorized by Parliament, means the Minister of Finance can go ahead. What we have here is $1.5 billion being spent without the approval. So it is outside the budget process. Why did the case go? The case was taken because the Public Accounts Committee, chaired by the Honorable Julius Espa, is completely frustrated by the United Democratic Party because they have a majority on the committee. That is the committee that should have oversight over whether or not money is being spent as approved in the budget, and if there's a deviation, to look to see what is the deviation and why there is a deviation. Oversight. What the law requires. If you are going to depart from what was budgeted, you bring a supplementary. The Finance and Audit Reform Act says, 1, you cannot exceed 10% of what was budgeted. 2, if you exceed that, it has to be exceeded by a special warrant by the Minister of Finance. The Minister of Finance says to the Financial Secretary, something urgent and unforeseen that we didn't budget for, or we had budgeted $1 million, it is now 1.5 million, we have to spend the money. I'm not having a House meeting very soon. Here's a special warrant, go above the budget. What does the Finance and Audit Reform Act say? At the next meeting of the House, you have to report that. It goes on to say that that special warrant is only valid for 3 months. You must get House approval for that expenditure within 3 months after that warrant has been issued. So you ask the question, Marlene, what does the Finance and Audit Reform Act require in these circumstances? It controls the expenditure of public monies. It ensures that the National Assembly has oversight. There is an obligation and a duty on the Minister of Finance, Dean Barrow, to report his excess. And further to that, there is a requirement that the National Assembly approve the excess. Failure to do so is criminal. Make no mistake about it. I questioned the Financial Secretary during the trial. And I said to him, did you tell the Minister of Finance that there was no money in the Consolidated Revenue Fund for these expenditures? Yes. So the Minister of Finance knew that there was no money? Yes. And he still issued the special warrants? Yes. When you look at the Finance and Audit Reform Act amended by Dean Barrow, it specifically says, knowingly violating the provisions of the Act is a criminal offense. The evidence, and we made sure we got a copy of it so that we have it. The testimony is that he knowingly violated the Finance and Audit Reform Act.
The response, however, in having spoken with the FinSec, is that it seems to be a common practice where they spend the monies and come afterwards and then present the supplementary allocations. And he's saying that, in essence, that has been a practice that has been there from time immemorial.
Right. And so when you have that type of activity, you reach a point where you say it must stop. Right? There is no doubt, and nobody will say, nobody can suggest that this is not a long-standing practice under PUP and UDP. What you have is an orgy of excess of criminality under this government. What you have is barrogance. You have governance by barrogance. The belief that you are not to be held accountable. He was the one who amended the law, right? The point is very simple. We have been demanding accountability. It has not, Marlene, you listen, I just want to answer the question. We have been demanding accountability. It has not been forthcoming. They have frustrated the Public Accounts Committee. It has not been allowed to operate the way it should. The Auditor General's reports have been held by the Minister of Finance and not brought to the National Assembly on a timely basis. Beyond that, let us not forget a significant portion, nearly $500 million in this excess is the Petrocaribe funds. You remember?
Yeah.
Roll it. You remember? Pibil and Tacos. You remember?
Yeah.
What is required here? And this is the point. This is the point. Up to today, there has been no accounting anywhere for how this money has been spent, into whose pockets it went, who received the hundreds of millions of dollars, who received the contracts. There has been no accounting. We are here to say, for the record, there will be a forensic audit of that $400 and odd million that was spent without oversight, contrary to law, contrary to the Constitution, so that the people of Belize will know where that money went, who benefited from it, and who must be held accountable.
Let me ask a question.
This case has established that what was being done was unconstitutional. Mr. Barrow nor Mr. Waite, none of them are above the Constitution.
Well, one of the things you have clearly outlined in the conversation, and I want to go back to the amendment that was made in 2011, you were right. I recall the conversation being about transparency and accountability, and the inclusion of criminal charges does have implications on this case. Why haven't we heard that as a part of the discussion? Who is criminally accountable?
Well, this was a civil law case, a constitutional case. In any real country, what should happen is the Director of Public Prosecution, the Commissioner of Police should go and say, excuse me, can I have all the evidence? Can I have a transcript of what was happened? Commissioner of Police should go and interview the relevant persons in the Ministry of Finance, in the ministries, and say, where was this money? Who gave the instructions? Where are the special warrants? One of the things we pointed out to the Chief Justice, not a single one of the special warrants was disclosed to the court. But we want to see them now. Who was the person who signed them? It has to be the Minister of Finance. So who is accountable? I would assume that very shortly, the Commissioner of Police is going to ask for all the documents, is going to compile a file and give it to the Director of Public Prosecutions. They are under a duty to do it. And if they don't do it, like in the Penner case, we will have to commence judicial review proceedings to order them to do it.
No, the question is, however, we're looking at a very short space of time. We have 6 months for the government to, in effect, go back and correct this thing. That's one. And two, the fact that it's an election year and the amendment to the Constitution would require the government working with the opposition in terms of drafting and going through that entire process. But then the elections can be called at any point in time. What effect, if any, will that have on this timetable set out by the courts?
There is only one, well, there are two relevant times. One, the Chief Justice has given them 6 months. The Constitution says you have 3 months between the tabling of an amendment and the passage of an amendment to the Constitution. So there is no reason why, if Mr. Barrow is serious and honest, if the Attorney General is going to perform his duty for a change, for the amendment not to be drafted this week, call a House meeting and table it so that the 3 months starts to run. What's holding them up? Why don't they do it?
Well, the question will be of a matter of political will, right? Whether they would have it within
It's
them.
more than political will, Isania, and this is what we have to understand. The court has spoken. The court has said you have behaved like rogues and criminals. The court has given you 6 months to correct it. It's not a matter of political will. It is obeying the order of the Supreme Court. Stop behaving like criminals.
Now, this was a critical case, and I don't want to just move past the fact that the Chief Justice ruled that, in fact, the Constitution should be amended and be retroactive as well. Can we get your perspective on this particular aspect?
It is sad. It is sad. What the Chief Justice has pointed out is that we were correct in saying that you cannot pass ordinary legislation, all of these supplementary appropriation bills, with retroactive effect because it is the Constitution that was violated. In order to correct a constitutional defect, you have to make an amendment to the Constitution itself. So we are going to be the only country in the world that is going to have an amendment that says, because the government did not obey the Constitution, we have to amend the Constitution with retroactive effect to approve retroactively these $1.5 billion in expenditure. So it's going to be a provision in the Constitution that is valid only for that purpose and for no other purpose, an utter shame and disgrace.
Is there any intent to appeal that portion?
Who is going to appeal it?
The PUP?
Well, we won't appeal it because we recognize that we have won and that is the only way.
So you are okay with the Constitution being amended with retroactive effect?
It is the only way that it can be corrected.
Okay.
It's the only way that it can be legitimized. However, and I think this is what talking to members in the party since Friday, people are saying. First of all, it needs 2/3 to pass.
Yeah.
They don't have 2/3. We do not believe that it is in the public interest. We do not believe that it is right to cover this up. To pass an amendment to the Constitution and say, boy, this is done. Retroactive effect, it's finished. No. Before that is done, there has got to be an accounting of the money that is now going to be approved retroactively. When they were spending the hundreds of millions of dollars and the government and the opposition was being critical of it, and they were laughing at us, and they were eating pibil and tacos and barbecue, right? And we were saying it is wrong. They had fun. Well, now the Chief Justice says you must correct it, and in order to correct it, you need the People's United Party's support.
Let me ask you a question.
It needs, first of all, before it is sanitized by an amendment to the Constitution, for the vulgarity, the illegality, and the criminality has to be exposed. There has to be an independent investigation into all of this. Then we will approve it.
So what I'm hearing from you is that the support by the opposition side will only come with a condition that this investigation will take place.
Among other things, which the party leader will announce.
If a new government takes over later this year, you mentioned earlier the fact that perhaps a forensic audit and an investigation will be done to look back at how these monies were spent. Would that allow for then criminal charges to be brought against anyone found culpable in having either misspent or did not properly account for these expenditures?
It will happen like the night follows the day, as it should. As it should. Mr. Wade picked up the Bible, swore on the Bible, and said, Minister, no money there for this. Roll it, my boy. See the warrant here? Spin it.
So you clearly said that the special warrants weren't presented in court.
Right.
But it was communicated that special warrants were issued.
The financial secretary said, and the only way that the money could have come out of the fund was by a special warrant signed by the Minister of Finance. And we pointed out to the court and we asked Mr. Wade, have you disclosed any of these warrants? We want to see them with the person's signature on it so that we know, as a fact, who authorized it, contrary to law, contrary to the Constitution. It was never put out in court. Well, the Commissioner of Police ought to be in the Ministry of Finance this morning asking for them. We want to see them. The public wants to know who did this.
There's a sense of cynicism, nonetheless, insofar as the police department and the Commissioner of Police acting on these matters. We've seen where, in respect of the Penner situation, the previous Commissioner of Police essentially sat on his hands, even though the mandate was there and it was very clear for him to act on what had developed. Do you believe then that, in all honesty, our new sitting Commissioner of Police...
Let me interrupt you. Let me interrupt you, all right? Don't believe that we don't have the documents. So they can try that game again and say, oh, we're asking for this document, oh, we're looking for this and we can't find it. Well, let's hear that excuse, then the documents will be provided. So do not, for a second, believe that this matter has come to an end. I want to focus on something. 2012, 2013, slippage, 100 million.
100 million, yeah.
Up to this day, it still has not been brought to the National Assembly. There was a general election in 2012. Listen carefully. There was an election in 2012. And I am saying here, that is why they have not brought those figures. It is going to reveal how the UDP financed their campaign. There is no mistake about it, Isani. When the financial secretary stand up in court and tell the Chief Justice that there was one person in the Ministry of Finance who is on top of all of those figures, and he got sick, and that's why we weren't able to present the accounts. 2012, 2013. 2014, 2015, 2016, the man's still sick. 2018, 2019, 2020, it's still sick.
But
where is the figures? Where is the money?
Allow me to jump in quick.
Who spend the money? Who get it? 2012, 2013, during the election.
The FinSec is saying that throughout this entire process, there has never been a charge of misappropriation. That's the first thing he said.
Not yet.
Secondly, he's saying, well, the money is all, everything will be checked out insofar as whenever it does actually come to the National Assembly, he says, well, look, everything will check out because the money has been spent in the most, I don't know, transparent manner. And when those documents or those papers come before the House, it will all check out. Do you believe that looking back at what was done between 2012 and 2013, in that particular context, that is sufficient enough a response?
Oh, you are serious?
Yes.
I'm putting the question to you.
Listen, no take me make kono mono. All right? The financial secretary knows very well that there's a problem with that year. Don't blame any public officer for being sick as the excuse why those figures have not been brought. I am predicting to you that there is a good reason, perhaps a bad reason, why they have not brought those figures. And I am suggesting to you that they know very well that what it is going to reveal cannot stand public scrutiny. All you had to do was tell a man who prepared the figures for 2014, 15, 16, 17, stop. Go to 2012, 2013, spend the next month and prepare that and bring it.
So there was ample time for that to have been addressed.
Ample time, more than ample time.
Let me just go back to what you said before, because you say it with such certainty. The allegation that you make that some of these funds went into the campaign for the election at around that time. I don't think anyone in the public is naive enough to deny what you may be saying. But in court, it's one thing. Where is the proof? Do you have proof?
Well, I'm not going to reveal proof on Channel 5 on Open Your Eyes this morning, but I speak with confidence.
You speak with confidence that?
I speak with confidence that there has been misappropriation of public funds.
For campaign purposes?
I speak with confidence. You see, you're going to hear all kind of spin this morning, probably start already, right? For example, $25,000 US being paid into people's account. Oh, we're not going to no law against campaign finance. So, nothing wrong with that. It's a criminal offense. I will talk about that after this. And I'm saying to you the same way. Contracts written down. I gave Isani a contract. It so happens that Isani is upon my campaign committee. And so, well, no, there was nothing illegal. The man had a contract. The man not performed the service, but the money get paid. Where did it go? So you're not going to say a check made out. Here it is for this particular constituency that says for political work. It's not going to say that, Marlene. It is going to say contracts given to people not approved by the contractor general, contrary to law, services not provided. When you look at the person who gets it, the person is a political crony, and the money goes into the campaign.
But this is another issue that has been long-standing, a lack of due process in terms of how money is dispersed, even if it is taken to the House.
But we agree, and what we are saying is that there has to be some time when it stops. It has to be. We just can't continue like this. You know what is $1.5 billion? With no accountability, without any accountability, no transparency. If you look at the supplementary appropriation bills, there are 3-4 pages at length, mostly. No details, no accompanying details explaining how these heads of expenditure were spent, on what, to who, what it is, recurrent or capital. It's just a ministry and an amount, a ministry and an amount, and they go to the National Assembly and say, pass these. And we say, well, what you spent it on? It doesn't matter, we have the majority, we pass it.
You know, and we're running quickly out of time for this segment, but I do want to kind of bring this home to people who are watching so we can understand. I think there is a level of cynicism as to how things happen and unfold with government. And from your perspective, what does this ruling change from the status quo that has existed for so long?
Well, I believe that, one, it confirms the criticism, and the court has now spoken, and I think that is important. Two, it says to any future government, the current government, because we will have an issue right now as to whether they're spending in excess of budgeted amounts right now. Current government and any future government, that you must comply with the Constitution and the Finance and Audit Reform. Otherwise, you run into a problem where, one, you can be criminally prosecuted, and two, you cannot correct it unless you can amend the Constitution again, which would be ridiculous. So it provides very clear guidance to the future as to how public funds are to be accounted for and expended. And
so from
finally,
this day forward, the government will not be allowed to access or use funds with this process they've been using in the past.
if they want to obey the law. It is now clear, beyond doubt, that what they have been doing is wrong, unconstitutional. There is no doubt about it. And therefore, the financial secretary, the minister of finance, who may change, cannot say that he or she does not know that this would be a wrong way to spend public funds. And let me just make one final point, because the question was asked whether the government is going to appeal. As I said on Friday, that would be preposterous and ridiculous, because I think you were there, Isani, when their attorney was in court after they had heard our submissions and after the evidence was taken, he conceded in court half the case. Now, you can't go to the Court of Appeal and say, I want to appeal if I have conceded that I lost or I should lose, and the Chief Justice has now confirmed it. So I would hope that public funds are not going to be spent on some expensive lawyer flying into Belize to go to Court of Appeal to say we conceded this but we appeal. This is the end of the matter insofar as that case is concerned. It is now stage 2. It's time now for all the documents to be revealed. It is time now for investigations to take place, and it is time now for people to be held personally accountable.
And what I hear from you is that the opposition will be taking the lead on this?
Yes, I think the party leader is on the radar right now, and I think that there is going to be more forthcoming very shortly from the party. The party, with all the cynicism, Marlene, has been calling, you will recall Julius Espat being pulled out of the House, Public Account Committee meeting after meeting trying to get up and running. We're demanding the Auditor General's reports being tabled and debated, and we are shut down at each time. You will recall the Speaker shutting down the debate on these issues. It is cover-up of UDP corruption. And this case provides a platform for us to move forward, to have some transparency, and to hold people accountable. We will not relent on this issue.
All right. Well, we will definitely have an update on this matter later in the newscast. What we will do here is take a break, and when we come back, we'll continue the conversation, but we'll be talking about something different. So please stay tuned.